All right. Welcome, everyone, to the Civil Justice Full Committee meeting for today. And we'll go ahead and get started and take the roll. Madam Clerk.
Representatives Bricken, Clemens, Curcio, Eldridge, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Russell, Smith, Stewart, Vice Chairman Jernigan, Chairman Farmer.
Present.
Mr. Chairman, you have a quorum.
Okay, thanks so much. Members, anybody have any personal orders or anything like that before we get started? Representative Stewart, you recognize?
Thank you, Mr. Chairman. We have some local celebrities here, not surprising, in Nashville. We have Judge Melissa Blackburn here and to speak. And in addition to being a great judge, she, I think, is a presiding judge still at the Mental Health and Veterans Courts. As a veteran, I really appreciate her work. We've also got Dan Eisenstein, now emeritus, who was a great judge for many, many years, helped all sorts of people in sessions courts here in Nashville. So thank you all for appearing.
Yeah, appreciate you all being here. I'm sure we'll hear from you here shortly. Members, anyone else have anything before we get started? Okay, seeing none. We have a calendar. I want to make an announcement. Item 2, that's House Bill 0477 by Representative White. That's rolled for 1 week. So once again, Item 2, House Bill 0477, rolled for 1 week without objection. Thank you. And then I have the first bill on the calendar. I'm going to let Vice Chair Jernigan take over because our guests are here, I think, to speak to that. So with that said, I'm going to pass the gavel down to Vice Chair Jernigan on that.
Thank you, Chairman. Members, the first item up to date. Got a motion and a second. Probably before us is House Bill 2663 by Chairman Farmer. Chairman, you got an amendment?
And I do. And thank you, Mr. Chair. I have Amendment 014166, which rewrites the bill, but just puts some small changes in there about just a little bit about funding, and then there's a couple typos there.
Can I get a motion amendment?
Right.
Got a motion and a second. It's before us. You want to, it makes the bill, you said?
It does.
Let's go ahead and put the amendment on the bill. All those in favor of the amendment, say aye.
Aye.
Those opposed, likewise, none. Ayes have it. So the bill as amended, Chairman Farmer, you'd like to explain?
Yeah, very good. And members, I had talked about this bill a little bit last week. What this does is, on behalf of Speaker Sexton, been working hard to move forward to create the Mental Health Treatment Act 2022. This would help with mental health court treatment programs. The purpose of this act is to create a new and continue existing mental health court treatment programs statewide. These programs will be administered by the Department of Mental Health and Substance Abuse Services to reduce the use of correctional services by offenders of mental health disorders by diverting them into effective treatment and support for mental illness, while also promoting public safety by reducing the incidence of crimes committed as a result of mental health disorders. And as we all know, we talk about mental health services all the time and kind of what's going on in our court systems. Been there firsthand, doing a lot of work for folks who've made some bad decisions, and sometimes it's caused by substance abuse and or mental health problems. And I always wanted to see something in place a little broader than what we have currently in place, especially out in East Tennessee and throughout the state. But I think this would do that. The funding would be funded by these programs will be funded by mental health drug court treatment program grant funds. Courts can apply for these funds, and the department will determine if the court is able to administer a mental health court treatment program and will award these grants accordingly. So they're grant funds, folks. The grant funds may only be used for costs directly related to program operations. This does not include paying for an additional judge or courtroom for the program. That's important. We're not creating any new positions. We're going to run this by what we have, the infrastructure that we have in place. And I think it's also important to know that this that in order to promote public safety for participants, shall not be a violent offender or sexual offender, and must have a diagnosis of a severe and persistent mental illness. A severe and persistent mental illness is a diagnosis of one or more qualifying mental illnesses or disorders determined by the department, and they must be willing to participate in the program. So with that short analysis, I'll renew my motion.
Thank you, renewing the motion. I believe we have testimony. So we go out of session for, Judge Blackburn and Judge Eisenstein. So let's go out of session. And if you would, Judge, introduce yourself and in your court, that'd be great. And then we can get right. How many minutes are we? 3 minutes you have.
Thank
All right.
you.
Thank you. Go ahead.
I'm Judge Melissa Blackburn. I'm the judge of the Mental Health and Veterans Court here in Davidson County. And this will make an enormous difference across the state. There are only 9, thank you, there are only 9 mental health courts across the state currently. None are funded by the state. In each instance, we have to go to the county and beg for money. In Davidson County, in 2019, we saved the state over $10 million in incarceration costs, and that's jail nights with the Mental Health and Veterans Court. And we had to ask for money to support the court. So you can imagine having money to support the court and the amount of jail nights that's going to save across the state. Because the difference in a jail night in a mental health night as opposed to a regular jail night, there's a huge difference in the cost that's incurred by that county. So this will totally change the trajectory of those individuals in those courts. The recovery courts can take individuals that are homeless, have mental issues, and usually have drug and alcohol issues as well, and totally change the trajectory of that family. It puts a family back together. I've had mothers that have lost their children, regained custody of their children, individuals that are homeless that were able to get back on their feet. They have housing, they have jobs when they finish the court, their fines and fees are waived, their cases are expunged, and they're able to start over. And that's because we take the time to wrap the services around those individuals. You just don't put them on probation. You provide all those wraparound services that they need while they're incarcerated, while they're on probation, to give them the strength and the courage to get done what they need to get done while they're in that court.
I'm Dan Eisenstein. I introduce myself as a has-been, not as emeritus, but I thank Representative Stewart for those nice words. I was elected in 2004 to the seat for General Sessions Court Division II. At that time, the court was run by Judge Fishburne, who just started it before moving to the criminal courts. There was a federal grant that funded the initial startup. Davidson County was one of the first 5 in the country, 5 mental health courts in the country. We were pioneers at that point. When I was elected, before I was actually elected, I had to run a primary and then a general election. When I won the primary election, I was asked to get funding for the court because the grant was going to run out during my first year on the bench, and I wasn't even elected. But luckily, the public defender and others joined with me, and we were able to secure funding. But we were the only court in Tennessee and remained that way for many years. Subsequent to that, there was one formed in Washington County, and then now there have been many formed. But the biggest problem to starting mental health courts is getting the money. Every other recovery court in the state, that is drug courts and veterans courts, get state funding. So mental health courts have been sort of the red-headed foster children, as someone said to me, to get funding. It will save counties in the state a lot of money. You've heard from Judge Blackburn. One thing she didn't say is the recidivism rate on those that make it through the court, which is most people, is very, very low. And it's not brain surgery. If you find somebody a place to live, you hook them up with services, you have them come back to court on a regular basis and see the judge, who becomes not only the judge, but frankly an advocate and a friend for this person. People respond. And it's sad sometimes that people have to get caught up into this to get services, but that's a fact so far. Hopefully in the future, pre-arrest will cut out some of the numbers, but there's always going to be people in the jail with mental health issues. And this is a program that can cut the cycle, break the cycle, get people into housing, get people into services, and not only save money for the jails and the prisons, but also for the psychiatric hospitals, believe it or not, because a lot of these people have gone through that process. So I like to say it is morally correct, it is the right thing to do, and it's physically correct and smart. So I really hope that you all will pass this bill and we can get funds throughout the state, because I know several of the counties have gotten in touch with me, as long as Judge Blackburn, who I must compliment for the wonderful job she does, both with veterans and with mental health. And I hope sometime that you'll go see a graduation that she performs on a regular basis, because you'll really learn how it works. And,
Judge, that's our time.
Thank you so much.
All right, appreciate that. So let's have some questions for our guest, Representative Parkinson.
Thank you, Mr. Chairman. I appreciate it. I know I was raising my hand to the wrong chair at the time when I was trying to be recognized. Mr. Chair, I know I'm going to be out of order with this before I ask my question, but I want to welcome, the students and friends and family from Tyner High School by way of Urban League of Chattanooga. If you will stand, and if y'all can make them feel welcome, please. I appreciate that. Thank you for that. And Mr. Chair, thank you for your indulgence. I just want to say to the judges, thank you for coming forward with the things that you're saying. And if you think about it, with this court, what this court is doing for those individuals that are having the mental health challenges is improving their quality of life. And that's the bottom line. And I think honestly, not just for mental health court, but for any people, most people, not all people, but most people that are involved in a criminal lifestyle. If most of these actions that we see in our, that pertain to crime have some type of financial incentive at the end of it or purpose, unless it's domestic, of course, or something like that. But, I don't know of many people that, if they were able to, feed their families or receive the health care and, or have a decent quality of life, that would be kicking your back door in. And so I truly applaud, what we're doing here. As a matter of fact, I don't know if I'm signed on or not, but I definitely want to sign on. Because this is a good bill and it's long overdue. Lastly, I would like to ask, though, can you, either the judges, can you quantify just a ballpark figure of the amount of money that we're going to be saving taxpayers by implementing these mental health courts?
Well, if you look at the jail nights in Davidson County, an average jail night is $190. A mental health jail night is $250. So if you look at that number, that's $60 a night difference. So if you think of how many people in your county are sitting in the jail every night, and I know our sheriff in Davidson County says between 80 and 90% of the individuals in jail have a mental health need. So think about that number when you're talking about how many in your county are sitting in jail.
Absolutely. And Judge, thank you for that. And just to echo your point, I think I brought this up in subcommittee. He was a warden back then, but a few years ago, our commissioner had spoken to the fact that 72% of the inmate population in our prisons were on mental health meds. 72%. And just imagine, had we had this in place, we probably could have averted a large percentage of them sitting in our prisons now, and costing, taxpayers a lot of money and anguish, with citizens, and the rippling effects that whatever their criminal activity might have been had on communities. And so, again, this is a great route solution that's been needed for a long time. I truly appreciate y'all and truly appreciate the sponsor for bringing this good bill. Thank you.
Thank you. Representative Smith, you're recognized.
Thank you, Chairman, and thank you, sponsor, for a great bill and to our speaker. And I want to applaud Judge Blackburn for her work along with some other leaders. I know in our county, I think you had a recent conversation with Judge Lila Statham, who heads our mental health court, and she's now the president of the General Sessions Court Conference. The funding is the problem, and I think that you've very well spoken that we've got plenty of patients because in Hamilton County, a minimum of 40% on any given census day are mentally ill, and sadly, we're incarcerating patients and not criminals. And so thank you for your work, and I look forward to shepherding this through. Thank you.
And I spoke with Ms. Statham this morning, in fact.
Thank you, Chairman.
Are there any further questions for our guests? Seeing none, we'll go back into session. Thank you for coming and testifying.
Thank you.
All right, we are back in session. We are on the bill as amended. Are any questions for the chairman? Questions been called. Without objection, we'll be voting on House Bill 2663 to go to finance. All those in favor say aye. Aye. Those opposed, ayes have it. You're off to finance. We're going to take item number 9, which is also Chairman Farmer's, since I have the gavel, and move it up next. Take it out of order, and we'll hear it next. Number 9, got a motion and a second before us. It's House Bill 2671. Chairman, we have an amendment.
And we do, Mr. Chair and members. It's
Motion and a second on the amendment.
It's 014447
That's what I have.
is the amendment. And what it does, members, I brought an amendment where it extended the COVID liability protection 6 months. And what this amendment does is it extends it for businesses to December 31st of 22, and for any healthcare providers whatsoever, anyone providing any sort of healthcare to individuals to December 31st of 2023.
Does the amendment make the bill? Is that-
Amendment, yes, it makes the bill.
Okay, well, question's been called on the amendment. Without objection, we're going to vote on the amendment, Amendment 14447. All those in favor say aye. Aye. Those opposed, ayes have it. We're now on the bill as amended. I guess you heard it as explained.
That's it.
Question's been called on the bill as amended. All those in favor say aye.
Aye.
Those opposed, ayes have it. Ayes have it. We'll be going to calendar and rules.
Thank you, Mr. Chair.
All right. And I will relinquish the gavel back to the chairman.
Okay, and thank you so much. Members, we have now, we're on item 3. That's by Representative Todd. He may need it to be rolled a couple spaces. So if we could, let's roll him 2 spaces. And for House Bill 1735, we'll roll that 2 spaces without objection. That brings us to item 4 by Representative Bricken. That's House Bill 2330.
Motion. Second.
You got a motion and a second, sir, and he stepped around. He what? Okay, very good. If we could just have a motion to roll. Very good. So item 4, House Bill 2330 by Representative Bricken is going to be rolled to the hill without objection. Thank you. That brings us now to item 5, House Bill 2418 by Representative Smith.
Thank you, Mr. Chairman. Thank you, committee. House Bill 2414 has an amendment.
Very good.
It's 13992, and that
You got a motion and a
amendment makes
second?
the bill.
So you're properly recognized it does make the bill?
Yes, sir. Thank you.
Okay. Members, we're going to go ahead and adopt that for her since it makes the bill. Okay, motion for that. Very good. So all those in favor of adopting House Amendment 013992 to House Bill 2418, say aye. Aye. Opposed, say no. Ayes have it. So now we're on the bill as amended, and ma'am, you're recognized.
Thank you, Chairman, and thank you, committee. This bill passed the Senate Judiciary last night, 9-0, and this brings into parity the probated wills and the common wills into those that do not have a will present. And this is permissive. If you look in Section 1.A of the bill, that after the 1 year of the date of a decedent's death, when duly proven, whether a resident or non-resident, this may be admitted to probate. So it is permissive, and this is a bill that's supported by the County Clerks Association as well as the Office of Administration of the Courts. And this essentially updates the code. It allows the establishment of certain requirements, that notification to families be made for the establishment of muniment of title for real personal property. And again, this is just to protect both the creditors as well as the property owners. And should there be a need to petition the court for a more expedited process, that process is permitted. And with that, Mr. Chairman, I renew my motion and I request the support of the committee.
Very good. Now it's time for questions or comments, and I have Representative Garrett on the list.
Thank you, Mr. Chairman, and I've talked with Representative Smith with my concerns of this legislation. I do probate work. I've also filed many minimum of title, and it's a relatively easy procedure. There's really two ways that you can file a minimum of title. I'm sure y'all never heard of that word, minimum of title. I can barely spell it. I have to check it every time I want to write it down of how to spell minimum of title. But what it does is it simply establishes title to real property when there's only the real property in someone's estate, and that's it. Now, there's two ways that can happen. Either we can't transfer the real property to the beneficiaries of a particular person's estate, or that person doesn't have their primary residence in the state of Tennessee, but they own a home here, and they want to open up an estate to establish title so they can sell the property. This legislation makes the process to establish minimum of title that only establishes the current owner of the property into almost full probate, where it would be expensive for the beneficiaries, it would be expensive for the people in the estate, and this is a creditor's bill. This is going to allow someone that inherits potentially their family property they can't sell it for a year, and if they can sell it, then they don't get the money. The money's got to be paid into court where they don't get it. So we're going to have their property, which is not subject to creditors. The person living never had a deal with any of the creditors to secure the property. This is mostly unsecured debt. And now they have another avenue to reach someone's property which they otherwise wouldn't. Creditors right now have the ability to open up someone's estate if they deem necessary. When you open up full probate, you are required to notify known creditors. If you notify the known creditors, they have 4 months to file a claim in the probate estate. If you don't know them, then the statute of limitations from someone's death is 1 year you have to file against the estate. That's why they want the 1 year in here, so the creditors can come in and take someone's property that they otherwise don't have the right to do. And so you are basically forcing this. This isn't permissive. This is going to be required to establish minimum of title under this statute. This is the procedure that you're going to have to do this. You are making what is relatively a minor petition with a court, and believe me, if any of y'all have been involved with a court, usually petitions aren't simple. This is making it extremely complicated just to establish title to property, to transfer it to its rightful owner. You are giving an avenue basically for full probate, and there's lots of folks that try to avoid probate just because the cost of probate. This is going to make them do probate to establish title to the property. So I've expressed these concerns. I believe that Representative Smith's judge in her district has brought this. I would suggest, and I would actually motion this to be summer studied so we can take a look at this to make sure that the process that's already in place to establish minimum of title, that we're not complicating a relatively easy procedure, Mr. Chairman. So those are my concerns about this legislation.
Okay. Have you made a motion for summer study?
Make a motion for summer study.
And I saw Representative Smith had her hand up.
I don't mind her
You mind her
speaking.
responding?
Not at
We'll
all.
I'll come back
Thank
to
you, Mr. Chairman, and I want to thank my colleague because we have, again, y'all saw us tussle in this room a couple of weeks ago, and this is not a surprise to me. I've reached out to my colleague, and he expressed some concern, even offered an opportunity to open this up for an amendment. And while I do hear his concerns and I do respect the process, I want to make sure that if this indeed is a burden for citizens, that we take a good look at it. Number one. Number two, I do kind of challenge the thought process because when you think of creditors, all creditors are not bad because, sometimes people owe people money. And there are many small businesses that are seated at this table. However, I am at the will of the committee. I appreciate very earnestly Chairman Garrett's expression and spending time with me on this bill. And so, Mr. Committee Chairman, I'm at the will of the committee and the vote. Thank you.
And thank you for that. And I promise Representative Garrett, I'll come back to him. So if you want to renew that motion, you can. Or
Yes, I would like to renew the motion, just so this can be further studied, so we're not further complicating a relatively easier procedure.
Okay. And members, I've got a proper motion. Do I have a second for summer study?
Second.
Okay. I've got a proper motion and proper second. So all those in favor to send House Bill 2418 as amended to summer study, say aye. Aye. Opposed, say no. No. Ayes have it. Bill moves on to summer study. That brings us to item
Thanks, Chairman.
6, House Bill 2023 by Chair Lady Littleton. And Chair Lady, it looks like I have Amendment 013942.
That's fine, and it rewrites the bill.
Okay, very good. And that rewrites the bill. So you've got a motion and a second on the bill, and I believe I heard a motion and a second on that amendment as well.
Okay.
Members, do we want to go ahead and get that in the proper posture? That amendment does rewrite the bill, so I'll just want to go ahead and vote on that. Looks good. Okay, so all those in favor of adopting House Amendment 013942 to House Bill 2023, say aye. Aye. Opposed, say no. Ayes have it. So we're back on the bill as amended. So Chair Lady Littleton, you're recognized, ma'am.
Thank you, Mr. Chairman. And I'm going to read this I'm going to have several of these second look bills this session. So I'm going to read what the second look is, if that's okay, and then move forward with the bill.
That's fine. Whatever.
Thank you. So these bills arrived from a year-long finding from the Second Look Commission, a department of the Tennessee Commission on Children and Youth. And I'm one of the 4 legislator members on the commission, along with Senator Wally, Senator Jackson, and Representative Love. The commission was created in response to the need to review and improve how the state handles severe child abuse cases. We meet along with child counselors, judges, law enforcement, DCS workers each month and do a deep dive investigation of some of the specially chosen cases. These bills I bring are a result of some of the issues and roadblocks we find that have resulted in legislation that will help the Department of Children's Services and Commission of Youth and Children to do their job and protect severely abused children. So House Bill 2023, it says a landlord, a person in control of a residential rental property, shall provide a case manager from the Department of Children's Services or a child protective investigative team with information, if known, on the address or location of a child who has been alleged to be abused or neglected and resides in or is located on the residential rental property. The landlord or person in control of a residential rental property is not liable in any civil or criminal action that is based solely upon the cooperation with the investigation by the Department of Children's Services or a child protective investigative team, except in cases of willful or wanton conduct of intentional wrongdoing. We had a little boy that wasn't at school, and the DCS worker went to the apartment building where the child lived, and the management would not give him the apartment building, and that child died a miserable, slow death that night. So we feel like had they given the apartment number, that little boy would be alive today. So, and we don't know how many other cases that it's happened, but the child did live. But this one, he died a slow, miserable death. So that's what this bill does.
And thank you for that explanation. Members, do we have any questions for the Chair Lady? Any questions or comments? Question's been called. Looks like we're ready to vote on House Bill 2023 as amended to move to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on to calendar and rules, ma'am. And that brings us back to, we had rolled a couple spots, Representative Todd, and that is not him walking in. So what we're going to do, without objection, let's roll him down to the hill of today's calendar. So that'd be House Bill 1735. Originally, item 3 will be rolled to the Hill without objection. That brings us back to Chair Lady Littleton. Item 7, House Bill 2024. You got a motion and a second on the bill, and you're properly recognized.
Thank you, Mr. Chairman. And this bill, it's another bill of the Second Look Commission, and it just makes a clearer definition of the Child Protective Investigative Teams. Make it easier and defines more of the sexual abuse and child abuse, and make it easier for the SIPP team to decide what to do with the child.
Okay, very good. Members, do we have any questions for the Chair Lady? Seeing none, we ready to vote? Looks like we are. So we're voting to send House Bill 2024 to Calendar and Rules. All those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Bill moves on. That brings us to item 8, House Bill 2354 by Whip Garrett. Motion. Second.
Thank you, Mr. Chairman. Appreciate that. I believe I have a amendment that I intend to move. It's the amendment number 13591.
Very good. You've got a motion and a second. Does it make the bill, sir?
It does make the bill.
Members, we want to go to get that in the proper posture and go ahead and vote on that. Okay, very good. We're voting to adopt House Amendment 13591 to House Bill 2354. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're recognized, Representative Garrett.
Thank you, Mr. Chairman. If I could I didn't take a moment of personal privilege at the beginning because this was important for this bill. This bill is called Noah's Law, and I'll explain why in a little bit, but I wanted to recognize we do have some members of Noah's family here. His grandfather, Gary Jekyll, his uncle, Adam Ennis, and his great-uncle, Barry Cleveland, and, of course, his grandmother, Edie Wainwright, is a school teacher. She couldn't be here today. And also Noah's mother, Amanda, couldn't be here as she's a nurse working today. But they are here. They're in about the 4th row. If y'all just wave to them and that's Noah's family. And so let me do the best that I can to introduce you to Noah, even though Noah is not here. Noah's a 3-year-old little fella that lives in Gallatin, had the cutest little curly hair that you could possibly imagine. And Noah's mom and dad were in a custody battle in Gallatin. Mom was, and still is, the custodial parent. Dad was the non-custodial parent, which means he did not have any overnight visits. Sometime in November, the dad was exercising his court-ordered visitation with Noah, and he took it upon himself to decide that Noah didn't need to come back to his mom. And so he took off. Y'all may have heard some of this in the news as of late throughout this particular saga that Amanda and her family that's here, along with Edie, the grandmother, went through in order to obtain Noah back. The good news is that Noah was returned safely and sound. About the only thing I believe that Noah didn't have was his cute curly hair when he came back. He literally traveled across this country. They found him in California. Here's why Noah's Law, I think, is a very important piece of what we are trying to accomplish today. When I've met with the family, along with the TBI and along with our sheriffs and along with our chiefs of police, one thing that Ms. Wainwright discussed and was concerned about was that as a 3-year-old young boy, Noah didn't have a voice, right? He wasn't able to exclaim to others that he was in danger, that there was something wrong, that he was supposed to go back to his mom, and his dad just decided that that's not what he was going to do. And so what we've tried to accomplish, you all have heard and are familiar with the Amber Alert system. The Amber Alert system is a federally regulated program and a federal regulated criteria that is supposed to be across this country used with those 4 prongs of the criteria to trigger the Amber Alert. In Noah's case, he had 3 of those. He had 3 of the criteria met 11 days from that Sunday or Saturday. I don't remember which one, but I believe it was a Sunday when Noah was supposed to return. It was 11 days that went by before the Amber Alert was triggered. That final prong that we had difficulty figuring out was whether or not Noah was in imminent danger or bodily harm. And so what this legislation does, it doesn't change the criteria of the Amber Alert, but since Noah's family was already in court, they already were before a judge there in Sumner County, and they were already having a custody battle between the 2 of them, what this does is if the non-custodial parent does not return the child to the custodial parent and 48 hours has passed, and that family, or Noah in this case, has been reported to the local authorities that Noah's missing, the judge can enter an order declaring that child in imminent danger or harm, which would thus trigger the final prong of an Amber Alert for the world to know that Noah's missing. So the prong here, this law will help law enforcement, will help the TBI, will help others realize that this child is in imminent danger and harm. Now, I will say this, and I will say this to thank the family, because the family in this instance had a lot to do with how Adam and Amanda and Edie put out on social media the fact that Noah was missing. They, in turn, became the fourth prong of the Amber Alert themselves. And I hope that something like this with this law will not make a family at least go to that strides in order for that fourth prong of the Amber Alert to be triggered under Noah's Law. So, committee, I ask for your support. This would assist law enforcement to make sure they use every tool in their toolbox so we don't have a situation again where there's too long. And one thing I failed to mention, within the Amber Alert being issued, in Noah's case, it was finally issued 2 days later is when we located him. While we don't attribute that only to the Amber Alert, but that certainly helped. And one thing that's great about the Amber Alert, just so this is not a knock on the Amber Alert system, 200 Amber Alerts last year were issued, and 196 of those were successful. So we have a program that works. We just need to make sure that we use it wisely. And I think Noah's Law helps in that endeavor. So with that, Mr. Chairman, I'll be glad to answer any questions, but I want to thank the family for being here, and I hope you can support this important legislation. Thank you very much.
Very good, and thank you for that explanation. Sounds like a great piece of legislation. Members who have any questions or comments for Representative Garrett? Anyone? For a vote? Representative Ogles, you're recognized.
Thank you, Chairman. And to the representative, I think this is a great piece of legislation. The only question I do have, is there any projection and increase in volume that will come from the change in this piece of legislation? Thank you.
Thank you for that question, and that's a good question. That's what a lot of our law enforcement wanted to make sure we don't get numb to Amber Alerts, where you have them, then people ignore them. So that's why the legislation is very narrowed, that there has to be a current petition in place where there's a judge already familiar with the particular case, and that child has to already be reported to the authorities. Those are all issues that were brought to my attention to make sure something like that doesn't happen. While we can't predict that behavior in the future, we've done everything we possibly can to look at this legislation to make sure we don't wear out the Amber Alert system.
Any follow-up, Representative Ogles?
No, thank you, Chairman. Great piece of legislation. I look forward to supporting it.
Very good. Members, anyone else like to say anything or any questions? Very good. Question's been called. Looks like we're ready to vote. Send House Bill 2354 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee.
Thank you, sir. And that brings us down to the hill of the calendar. And next I have on the hill is actually Representative Bricken. Sir, do you need a moment to, and I can let Representative Todd move forward, or do you want to go ahead and move forward? Okay, you ready? All right, members. That brings us back to item 4, House Bill 2330 by Representative Bricken. You've got a motion and a second. And I'm looking at a couple of amendments here, sir. Do you know which one, or? Very good. And that's Amendment 14284, and that makes the bill according to the sponsor. So let's go ahead and get that in proper posture. How about that? So motion, second on the amendment. We're voting to adopt House Amendment 14284 to House Bill 2330. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Representative Todd, you're recognized, sir. Excuse me, Representative Bricken, you're recognized.
Thank you.
In my mind,
Thank you, Mr. Chairman.
Yeah.
House Bill 2330. This bill is really for all Tennessee gun owners that have taken the extra effort to obtain the enhanced gun permit, that have taken the 8-hour training course. This change will just convert the 8-year license to become a lifetime license. That's the essence of the bill.
Very good. You've heard that explanation for our sponsor. Members, who have any questions or concerns for Representative Bricken this time? Okay, good. Representative Clemens, I believe I saw your hand, and the question has been withdrawn by Chairman Curcio. You recognize.
Thank you, Mr. Chairman. And sponsor, I know that the Department of Safety had raised some concerns about this in the subcommittee. were their concerns addressed by the amendment?
Yes, it was.
And, sorry, Mayor. So,
You recognize it, please.
and then there was the issue with regards to individuals having the option and not having to pay the additional fee. Was that also addressed?
The additional fee.
I think they could renew or not pay the fee. I don't remember what their concern was in that regard, but.
No, the bill still has the $50.
Hey, Representative Bricken, is your mic on?
Yes, I'll probably.
Okay, there we go. I didn't know.
Chairman.
You're recognized, sir. Go ahead.
It still has the original renewal fees that were in the original bill. So it's a $50 fee to convert your license to a lifetime license.
And there had been the concern raised by the Department of Safety with regards to someone who may choose not to do that for one reason or another, and them not having the option or having to expend those funds rather than just doing a renewal. Is that?
Well, that was addressed in the amendment. If their 8-year license expires, but they later choose to renew it, they can come back to safety and get that license for a $50 filing fee.
Very good. Any follow-up, Representative Clemens?
No, thank you, Mr. Chairman.
Very good. And Vice Chair Jernigan, do you have a question for our sponsor?
Yeah, a question. Well, I guess it's a question. It's more of maybe a comment. I think you feel this may be a good thing that more people may get the license after the amendment addressed the concern I had, but because it's lifetime, then more people may get a hand permit. Would you agree with that, I guess?
You recognize, sir.
Certainly, that hopefully is a byproduct of this. The 8-year license goes to $100. So for $100, you can have a lifetime license that is recognized by, I forgot how many other states in the nation. So I think it has value. So hopefully more citizens will choose to take the 8-hour full enhanced course training and become lifetime permits.
Very good.
Well, thank you. And anything to encourage to get the permit, I would appreciate. So thank you so much.
Very good. And that brings us back to Chairman Curcio. Do you want to, on the question? Question has been called. So all those in favor of sending House Bill 2330 as amended to finance, say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. And that brings us back to item 3, House Bill 1735 by Representative Todd.
Thank you, Mr. Chairman.
You're welcome.
Appreciate your indulgence today.
And I'm looking at an amendment 13807. Is that something you'd like to move forward with?
Yes, sir.
Very good. You've got a proper motion and a second. Does that make the bill?
It makes the bill, sir.
Okay, members, we're going to go ahead and vote and get that in proper posture. Looks like we do. So all those in favor of adopting House Amendment 13807 to House Bill 1735, say aye. Aye. Opposed, say no. Ayes have it. We're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. This bill before you does some fairly simple things. I think most recognize that in our U.S. Constitution, 18-year-olds are adults. We send them to war. We require them to sign up for selective service. We expect them to vote. But we have restrictions on 18-year-olds now in our law, among other restrictions that have been placed in years past for the ability to protect themselves. Second Amendment guarantees every person in this country that's legal age, 18 and over, to be able to keep and bear arms. And that right shall not be infringed. And I'm just trying to remove one of those infringements for 18 to 20-year-olds. There was a question in subcommittee concerning reciprocity that I certainly was very concerned about, because I don't want to hurt the ability for folks with permits to be able to carry in other states we already have agreements with. But with our research, what we found are a number of things. That right now, 25 states allow Tennessee residents aged 18 and older to carry if they're legal to do so in Tennessee. An additional 11 states allow reciprocity permit holders but exclude 18-year-olds per their conditions as referenced in another statute. Of the total states, 12 states refuse reciprocity in total. Vermont has no written agreement with Tennessee. It has honored the Second Amendment and has not infringed on the rights of citizens to keep and bear arms since its creation as a state, and trusted non-criminal travelers as well. So you as a Tennessean can go to the state of Vermont and carry, open or concealed, any firearm, long gun, handgun, no issues there. Never has been. They've never had infringements on the Second Amendment right in that state. And what this bill does, it simply removes that infringement for 18 to 20-year-olds that we entrust some very serious responsibilities and expectations with. That's simply what this does, and I'll be glad to take questions.
Very good. And then, just so we know, I've got a couple folks that want to testify, but I had Vice Chair Jernigan's hand. I saw his hand.
Well, no, I'll wait till after testimony.
Okay, that's fine. Very good. So without objection, members, we're going to go out of session and hear from, I got Elizabeth Stroker. She was on the list to speak with Department of Safety. And Ms. Stroker, I know you know the drill there. Make sure your red light's on. Introduce yourself in 3 minutes.
Yes, sir. Elizabeth Stroger, Legislative Director for the Department of Safety. I'll keep this brief. I spoke in the subcommittee as well. Again, the Department of Safety is flagged on the bill, opposed to it as written. One of the biggest issues we see is Chairman Todd brought up is the potential loss of reciprocity. It seems like we could potentially lose it with other states, and so we feel like that would be a pretty big hit for current permit holders if they would now not be allowed to travel with their permit out of state. And so just wanted to reiterate that again from subcommittee. I won't take up too much of the committee's time, but we still have those concerns, and we are still against the bill.
Okay. Members, any questions or comments for Ms. Stroker? Representative Ogles, you recognize, and then Representative Smith.
Thank you, Chairman. Do you know the 12 states that are not going to honor or give us reciprocity now that if we pass this as written?
Ms. Stroker.
I don't know those states. I don't have the list that Chairman Todd has, so he may could answer that. But our data we pulled that we could lose reciprocity with up to 21 states is based on what our poll is. But no states would give us a definitive until something were actually passed when we do our annual survey with them.
Representative Ogles, any follow-up?
So it's your department's understanding that though we're trying to expand Second Amendment rights, that we in essence could lose the right to carry a firearm in up to 21 states?
Ms. Stroker?
That is correct, yes.
Thank you.
And next on the list I have Representative Smith, ma'am.
Thank you, Mr. Chairman. And Ms. Rucker, I'm just curious, when we're talking about a constitutional right, and I do understand that adulthood is recognized in legal code most everywhere to be 18 years of age, can you cite a reference that the Second Amendment is limited to I understand state law, but looking at constitutional rights, what is it that you're predicating the department's opposition? Because clearly you're offering testimony that you're lobbying against this bill. So what is the predicate of establishing that an 18-year-old should have their Second Amendment rights limited?
Ms. Stroker?
Yeah, no, absolutely. Great question. There's plenty of Supreme Court case law that shows that Second Amendment rights can be restricted if they are reasonable. One great example relative to 18-year-olds is that you actually have to be 21 to even purchase a handgun specifically. And so that is why it is 21 in the code now. You cannot purchase a handgun from a dealer currently until you are 21.
Representative Smith, you recognize.
And this is just me transferring a situation from another department onto this situation. In another department, we passed a law last year, and the department is not currently enforcing that law. So if this committee moves this bill forward today for my colleague and our legislature passes it, will it be the position of the department that this will be a law that's enforced, or will there be some attempt to circumvent that? Thank you, Mr. Chairman.
Ms. Stroker?
I don't understand the question. Sorry. Are you asking if we're not going to follow the law as passed?
Representative Smith, you recognize.
Put simply, yes.
No, we follow all laws that are passed. We're just expressing our concerns with it.
Thank you.
Very good. Members, anyone else? Chairlady Littleton, you recognize.
Thank you, Mr. Chairman. I just need some clarification about the 21 states that wouldn't accept it. Would they not accept it if they're over 21, just between the 18 and 20? I mean, I need that clarified, please, if that makes sense to you.
Yeah. Ms. Stroker, you recognize.
Yes, ma'am. And again, it's potentially up to 21, as Chairman Todd alluded to. That's just an estimate of how many we could lose reciprocity with. And again, it could be that they won't honor the entire permit, or it could be that they won't honor it for a certain age range. We just don't have that information yet. We couldn't get firm responses from everyone when we reached out.
Yeah. Chairlady, you recognize.
I think it would clearly be for the ones that are 21 for the other states. Surely they wouldn't punish everyone. I'm just saying, thank you.
They can make their own determination based on honoring out-of-state permits, just like we can.
Okay.
But you don't know for sure.
Chairman Russell, you recognize.
Thank you, Chairman Farmer. I've got a clarification question. How does the state of Tennessee determine reciprocity, and could you tell us the process?
Ms. Stroker, you recognize.
Yes, we, and all of this information, actually, if anyone wants to know, we keep the reciprocity list on our website with all of our handgun permit laws and application requirements and things of that nature. We do an annual survey with all of the 50 states, other 49 states, and we evaluate their laws, they evaluate ours, and then that's determined when reciprocity would be honored or not. We have some formal agreements with some states, and some it's just kind of understood based on the laws of that state.
Chairman Russell.
And is that sent by the Department of Safety's legal staff, or who sends that out?
Ms. Stroker.
That's done by our handgun unit within the Highway Patrol.
Thank you.
Very good. Anyone else? President Garrett.
I'm curious, with our agreements with other states, are there any other states that have this particular law that you can own and possess a gun at 18, and then we wouldn't honor that under our reciprocity agreements?
Good question. Ms. Stroker.
We pulled that information. I think I talked about it in subcommittee. I'd have to go back into my records, but there are, I believe, 9 other states that have something similar, and some of those we do not honor, and some of them we do. I'd have to pull that information, and Chairman Todd may actually have it, so he may be able to answer it as well.
Very good. Follow up.
So there's some agreements under our reciprocity agreements, I can never say that word, that we would not honor a state. We would not provide them that protection for someone that's 19 years old, that's legal to carry in their own state through our own agreements. My question is, why would we not? Why would we revoke our agreements with them because of that reason?
Ms. Stroker.
And I'll answer that 2 parts. One, it wouldn't be that this bill isn't saying that we're going to revoke reciprocity with other states. That decision is made based on a number of factors, based on if the state has any type of permitting laws, what type of firearms they may allow or not allow. So it's much more complicated than just the age range. There could be other factors, but I would be more than happy to get that information from our handgun unit. They just did a cursory review based on 18 being a factor, but I'd be more than happy to get that information on why we don't have agreements with those states.
Representative Garrett.
Yeah, that would be nice, since this is a major reason why you oppose the legislation about the reciprocity. We need to know all about it. And I don't know why in the world Tennessee would not honor an agreement from another state that would allow this under our agreement. So yes, I'd like to have that information. Thank you.
Very good. Any follow-up? Any other members' questions, comments for our speaker? Representative Clemens, you recognize.
Thank you, Mr. Chairman. And so last week we discussed in the subcommittee, right now there is the ability for 18 to 20-year-olds to carry firearms with a list of conditions, military service, honorable discharge, and similar requirements. So 18-year-olds are not being completely denied this right. But even when we did that, I think you mentioned that we lost reciprocity with a few other states under current law. Is that not right?
Ms. Stroker?
We did discuss that last week. That's my understanding, is the reason why it was limited to so many restrictions around certain military exceptions was because it could put reciprocity in jeopardy.
Okay, thank you.
Very good. Anyone else? All right, thank you so much. And next on the list, I have, if I messed your last name up, I want to apologize in advance. I have Zach Mahy. Okay, very good. Sir, if you just come on up here and just let us know, just go ahead and state your name for the record. We'll be sure there's a little red button. You can push a light will come on. There's a little speaking face down there. And then, I'm sorry, on the mic there in the front, there's like there's a button you can push and a red light will come on. See it?
Is it working now?
It is.
All right.
Very good. If you would, sir, just go ahead and just introduce yourself to the committee. Let us know who you're with, and then We'll give you 3 minutes to.
All right, thank
present.
you. Hello, committee. Thank you all for hearing me speak today. My name is Zach Maya, and I'm a student at Vanderbilt University. I'm a volunteer with Everytown for Gun Safety and a member of the Students Demand Action National Advisory Board. I'm here today, along with Everytown for Gun Safety, to strongly oppose House Bill 1735 and encourage you all not to advance it. Since I joined the gun violence prevention movement in 2019, one of the most hurtful experiences I've had have been when legislators hear their constituents' calls to action and claim to care about Americans' lives, yet fail to commit to real action, and sometimes even scale back common sense gun laws. In Tennessee, for instance, gun deaths have increased 48% from 2011 to 2020. But instead of enacting popular gun law reform, this legislature passed a permitless carry law that was opposed by 59% of Tennessee voters. And today, it's considering expanding it. People aged 18 to 20 are 3 times more likely to commit gun homicides than those 21 and older. In an average year, 30 18-year-olds die from gun violence in Tennessee, 72 of which are homicides. This bill would make any danger caused to the Tennessee public or Tennessee police officers by the permitless carry law last year significantly worse. Personally, I know far too many people who have died and who have buried friends and family or had trauma themselves as a result of gun violence, including the family of Toledo police officer Anthony Dia, who was shot and killed responding to a call just 6 miles from where I grew up. Now, I know that each of you is being pushed by different actors to vote a certain way on this bill. As a senator in my student government, while maybe a little bit less influential than you are, I've experienced just a taste of that. At times, I've faced pressure from every person in the room to vote a certain way. Yet, there have been times that I'm the only person who would vote nay on a bill I didn't believe in. In that same way, I'm asking each of you to consider the implications this bill will have and make a choice that reflects what Tennessee actually needs and wants at this moment, regardless of how you may have been lobbied to vote. I know, and I'm sure you all know, this law will only put Tennesseans in more danger. So on behalf of every American and other person who is at risk of being harmed by this bill, I encourage you all to please vote no. Thank you.
Very good. That's almost 3 minutes on the dot. Great job. Members who have any questions for our speaker? I have Representative Smith on the list.
Thank you, and I appreciate you taking the time to be here and applaud your activist interest as a student. So way to be here. One thing I just want to kind of set for the record, I've never been lobbied about this bill. And so there's not an interest other than me being able to read the Constitution and the fact that if you were called into the military, I'm assuming that you would be of the age that you would be required to serve or be asked to serve and fire a weapon. One thing I just ask for you to think about is that while we don't give keys to the car to a 16-year-old until they do some things, show some demonstration of maturity, we certainly don't prohibit them from driving a car. And certainly by the age of 18, we do. And I would assert to you that last year we had over almost 1,300 deaths due to car accidents. And we're not overwhelmed by the anti-automobile lobby. And so what I would just simply ask for your consideration is, while I know that there's a lot of easy bullet points and activist notations, keep a soft heart, because we're not here to. This is not a partisan issue. This is an American issue. The very unique thing that makes America our wonderful country is we have enumerated rights put forward in our Constitution, one of which is in the Second Amendment. And so while I know it's fearful, but automobiles don't cause accidents. Really, guns don't cause accidents. It's the people behind them. And so I do understand, and I thank you so much sincerely for being here, and want to encourage you to keep moving forward. but always put the framework around that with every right comes a responsibility. And while we do allow certain 18-year-olds to have certain responsibilities, I think that we can trust, I would trust you with a weapon, and I would trust you with my life. And I would hope that if I were walking down Representative John Lewis Parkway and I was approached as a female, and I bet your body strength is stronger than mine, I would trust you to interact on my behalf. And that's what, we're not all going to war, we're not all going hunting. Most of the time, many people carry a weapon for self-defense. So, Mr. Chairman, I thank you for the time, and again, I applaud you for being here. Thank you.
Thank you.
Very good, thank you. Any
I can
follow-up?
Yeah.
Go ahead.
Thank you for your remarks. I want to apologize if I seemed like I was trying to put any blame or anything like that. It wasn't my intention at all. You brought up automobiles and the licensing system we have in the U.S. And how we have 1,300 deaths a year in Tennessee because of automobile accidents. But I want you to consider how much worse that would be if we didn't have a requirement for 16-year-olds to get training and have a license to drive. Automobiles are not made to kill people, but they do because people cause accidents, you're right. But people only can cause accidents with automobiles because they have access to the automobiles. And it's the same thing with guns. If you allow every person to have a gun, then yeah, it's the person who causes the accident, it's the person who pulls the trigger, but they have the gun because you allowed them to have the gun. It's not necessarily the gun itself that's causing it, but it's the person who has the gun in their hands. And in terms of our rights as Americans, the Constitution allows for reasonable restrictions on those rights in order to make sure that everyone's safe, because we can't all exercise our rights if we're dead. You know, like if every person is allowed, if our society gets to a point where people are dying left and right, that's not a reasonable way to exercise our rights. It's not free. It's not freedom. And so that's why it allows for those restrictions, because they make sense and they save lives. They prevent deaths. And so as you consider this in the terms of people's rights to have guns, consider the fact that people can still get them. You know, they just have to get training. They have to apply for a permit. There's a process, because there's a process with automobiles. It's what helps us keep us safer, and it's what, when a police officer approaches a vehicle, it's what informs them that a person has a firearm with them. It just keeps us safer to have those restrictions. And if a person has good intentions when they want to carry a gun and they want to defend themselves, they should want to get training. Like, a person isn't going to be able to use a firearm to defend themselves if they don't know how to use it. And so ensuring that someone knows how to use a gun when they get it ensures that they can actually use it to defend themselves, if that's what they are trying to do.
Representative Smith, any follow-up there? Okay, very good. Next on the list, I have Representative Parkinson.
Thank you, Mr. Chair, and thank you for your comments, sir. I just want to respond to my colleagues' comments about the military. I am prior military, Marine Corps, and you know, when I went in the Marine Corps at 17 years old, and apparently they were violating my constitutional rights because they did not give me a weapon when I went into the Marine Corps. Not until I was adequately trained to carry that weapon. And I'm gonna be honest with you, when I went in the Marine Corps and we started our training, I sucked at shooting. I might have shot my platoon members' target 10 targets away while aiming at mine, right? But through the training, after the training, I became an expert shooter in the Marine Corps through that set of weeks training, and I became very proficient at shooting. And I talked to my colleague, Representative Todd, and I understand what he's trying to do. And I've expressed this to him also, that, you know, I could be on board possibly with this legislation if there were, you know, a step up, you know, training. Let's say if 18 to 21-year-olds were required, to go through gun safety training before being able to carry like this. And that is exactly my concern, is that, and I said this before when we went to open carry period, that, it's the ignorance of the law that's going to be the issue, for those people that are carrying, that don't understand everything that comes with, just even pulling that weapon from your holster. And that's a felony off the top, aggravated assault. If you just even brandish a weapon in a certain situation, somebody's trying to break into your trunk of your car and you brandish a weapon, that's ag assault off the top, felony, right? And God forbid you actually fire that weapon and shoot someone, and now you're looking at possibly attempted murder. Because what happened when I went through my gun safety training after the Marine Corps, and I actually took my 11-year-old daughter with me, had her take the test and everything. She learned everything that I learned. Was, what they taught us in there was, when it's appropriate to defend yourself with a firearm, when it's appropriate, how you can carry it, situations and so on and so forth. And because I took my 11-year-old daughter through that training, I don't have to worry about, these incidents that happen in our communities where some kid picked up a gun and shot another kid or something like that. I just think, while I understand my colleague who I'm fond of, his intent with the bill, and I understand it's a constitutional argument because he's obviously a good litigator. I don't know if he's an attorney or not, but he can make an argument. But there is still, to me, in my estimation, it could be a better bill if we created a step-up license for those that are 18 to 20 years, just like we do with a driver's permit, or before they become drivers out in our community. So thank you, and thank you for your testimony, Mr. Chairman. Thank you, sir.
Thank you. Next on the list, I have Chairman Russell.
Thank you, Mr. Chairman. Did I hear you say that gun violence has increased up to 2020?
It's, can I respond?
Yeah, you can. Go ahead. You recognize.
Gun violence has increased 48% from 2011 to 2020.
Chairman Russell.
What happened from 2020 to 2022?
You recognize. Go ahead.
I think I haven't looked at, the data's not completely solidified yet. I think it takes a little bit of time. That's why a lot of statistics are a little bit backwards. But my guess would be that it has increased, because I know nationally it has, as a result of COVID-19 and social unrest, that was caused by isolation and poverty. I know that gun violence has increased in general in the U.S. I don't know about Tennessee specifically, though.
Chairman?
So you didn't check and see if it increased all the way up to the year 2022 to today's date?
No.
That's all I got.
Okay, very good. And I don't have anybody else on the list, and that was going to be my question, is where you pulled your data from, and you answered it nationally. And I know we had all the riots going on, and we had some folks actually encouraging violence, and it wasn't here. But there were several other big cities across this country that was a disaster. But I have Representative Eldridge. Sir, you recognize?
Thank you, Mr. Chairman. A few minutes ago, you talked about the number of people 18 years old that had died from gun violence. Would you repeat that for me, please?
I think you're referring to when I said that in an average year in Tennessee, 30 18-year-olds die a year.
30 18-year-olds?
Mm-hmm.
Okay. Okay, I was thinking the number was a little higher than that. Do you think that, I mean, one question that comes to mind, and 30 people, it's tragic that anyone's going to die. The number came out earlier that the age, you can't buy a gun at 18 years old. You got to be 21. Where do you think, or where do you have any information as to were they legally purchasing a gun somewhere, or what were they doing? I mean, and was it someone older that shot them? Do you have any information about that, or?
I'm sorry,
My question is how did an 18-year-old, I mean, was it someone older that shot them that was that purchased a gun legally, or were they in possession of a gun illegally?
I don't know for sure, based on that statistic, how many of those 18-year-olds were shot by someone who's older than 21. But I do know that in many cases, when a shooting is committed by someone who is below 18, they get those guns from relatives. That happens a lot if like the family doesn't store their guns safely locked out of reach of their children, then children can get access to them, and that's where a lot of mass shooters, for example, get their firearms. So it could be from there. It could also be stolen. That happens pretty frequently too. I don't know specifically how many of those 18-year-olds were shot by other people below or above 21 specifically.
Okay, thank you. Thank you, Chairman.
You're welcome. Members who have anything else, any questions or comments for our speaker? All right, seeing none. Thank you so much.
Thank you.
Without objection, we'll get back in session. All right, we're back in session now. And Representative Todd, you can take your spot there at the podium and move forward.
Thank you, Mr. Chairman. I first want to dispel any rumors that I'm an attorney or even related to one. So, but, and you know, one of the things that I appreciate the question about the 18-year-olds being killed, because I don't even see the relevance of that. You know, we're talking about 18-year-olds or 16 or 17-year-olds that are killing people, not being killed. And the statistics that were presented are criminals. We're talking about criminal activity, and we unfortunately don't get to legislate to criminals. They don't pay attention to us. We legislate to law-abiding citizens. And each and every one of you has taken an oath of office, just like I have, to uphold the U.S. Constitution first, Tennessee Constitution. And my friend has also taken it more than once in his military career. So that is our obligation to the citizens of this state. First and foremost, we don't take an oath to do what our citizens ask us to do. We don't take an oath to do what a lobbyist asks us to do. We don't take an oath to do what a poll tells us to do. We take an oath to uphold the Constitution of the United States of America. And that Constitution, in plain English, says that your right to keep and bear arms shall not be infringed. Doesn't show that we have a right to operate a vehicle. That's a moot argument. That's apples and oranges. We're not talking about an equal right. We're talking about a civil right here that each one of us is granted by God. And this is for our protection and the protection of our country. We see what's going on around the world right now. If what was happening in Ukraine were happening right here, we would be hoping every 18-year-old would be willing to come get a gun. I can assure you of that. That's the primary reason that the Second Amendment is there. It's to protect us from a tyrannical government. And we could have that as easily here as they can there. It just takes a few days. But we have that protection. Other countries know we have that protection, so we don't get invaded. But certainly the other principle here is the self-protection. We expect folks to get out, they can carry in their home, they can possess in their home, they can possess in their car. But we expect them to get out on the streets and rely on law enforcement to protect them. They have no obligation to step in and protect you. You may have forgotten that, but by law, they have no obligation to protect you. They are supposed to show up and take a report. And many of them lay down their lives to protect you, but they have no legal obligation to do that. So I just, I'm asking about, again, your core principles here, not what some lobbyists has asked you to do. That's a false argument. This is about your principles based on your oath of office to the Constitution of the United States. And the issues that were presented about the reciprocity, I'll get back to that. We already have, as was noticed in testimony, we already have 18-year-olds right now legally carrying in this state. They have the military connection. And we only lost 4 states, at best, at the most 4 states. That's a little questionable. I've gone to safety's information that they provide. It's not the easiest to sort through, but only 4 states. And they just said, okay, 18-year-olds, you can't carry in our state, 18 to 20-year-olds. But everybody else is fine. So I would argue, I think very emphatically, that we will not lose any reciprocity over what we already have right now. There's no reason to. We already have 18-year-olds, and those states just simply carved that group out and that's all. They didn't say we just wipe it all out completely. So that, I'd be glad to answer any questions, but those are certainly the points I wanted to make after the testimony.
Very good. Vice Chair Jernigan, you're recognized.
Thank you. And well, let's talk about the Constitution, since we brought that up. It does say in the Second Amendment that it shall not be infringed. It also does say that it can be well regulated. This bill includes constitutional carry, is that correct?
You guys can go back and forth, just be respectful of one
Thank you,
another.
Mr. Chairman. Yes, sir, it does.
All right, so you would not need a permit. I'm going to equate it to another amendment in the Constitution. The 21st Amendment gives us the God-given right to drink alcohol. 21 years is the age. This would be saying, if I doubt any colleague here would lower it to 18 and then say, you know what, you don't need an ID to go buy alcohol. I don't think anybody in this room would vote for that. But they can go to war. You know, they can vote. Representative Parkinson said that, you know, he's well trained. I mean, even the military has standards. They don't take any 18-year-old. You know, and if you're drafted, they train you. You should vote. I agree. Vote to 18 because you need to vote for the person that's going to send you to war. I agree with that. But the Second Amendment doesn't say anything about age, just like the 21st Amendment doesn't say anything about age. We have a God-given right for both, but I don't think anyone in this room would entertain going down to 18 years old to drink alcohol. And that's apples to apples. That's not, it's in the Constitution. So, you know, and another colleague of mine mentioned that guns don't kill people, people kill people. We're about to add a lot more people to the list. And I've had 4 18-year-olds. They can't clean the room, much less lock the door of their car for a weapon to be stolen. I think the bill it's unnecessary. I think it's unnecessary. I think where we are now at 21 suffices. I don't have a question. Those are just my comments. And thank you, Chairman Todd.
Very good. Do you want to be recognized?
Yes, sir.
Good. Go ahead.
I would disagree with you. Not everyone in this room would not vote for that. I would certainly vote. If you bring a bill to lower the drinking age to 18, I would vote for that. Still need to check ID because that's how you verify the age. But if we expect our 18-year-olds to go to war, and we expect and require them, I'd say require, we certainly expect them to go vote at 18, then this is the same difference. I don't know how we got to 21 on those other laws. I wasn't here. But I certainly would, I can't argue one without the other, just like you. But for the same reason, I think we need to move forward with this, removing this infringement from these rights that these 18-year-olds and 20-year-olds have. Thank you, Mr. Chairman.
One follow-up.
Yeah, go ahead, Vice Chair. You recognize.
Thank you. Yeah, we got to 21 because Ronald Reagan said they're going to take away the federal funding if we don't raise it to 21. So I think that pretty much nipped that in the bud. I don't think federal funding is tied to this, but it was a conservative president who took it away from 18 to 21, regardless if they went to war or not.
Representative Stewart.
I just have a technical question. What would be the interplay between this law if it were passed and guns, firearms in the schools? I'll give you a concern I have is that I believe carry permit holders can carry weapons in their vehicles. And I'm looking at 39, 17, 13, 13. So can we assume now that like a public school, you could have a large number of 18-year-olds bringing weapons to school that otherwise couldn't before your bill was passed? Am I reading that right?
I'm understanding that that is federally prohibited, so this would not affect that.
You think there's a federal prohibition on school? Tell me a little more about that. That's something I hadn't heard about.
That's as much as I know, sir.
Okay, so you're thinking that this bill will not allow guns in school areas? It won't expand the right of people to bring a gun in a school area?
That is my belief, sir.
Okay, because that would concern me. I would think most voters wouldn't want more people bringing powerful weapons onto school grounds. That'd be my concern, among others. Thank you.
Thank you. In fact, I'm curious about that. Can I go out of session and have legal say something about that, please?
Elizabeth and Sonia Legal Services. So federal law and state law both prohibit guns in the school, but school parking lots fall under 3917-1313, which allows anyone who is a permit holder or who carries pursuant to 1307G, which is what we commonly call constitutional carriers. It allows them to transport and store a firearm in their vehicle in the school parking lot. Now, that's a violation of federal law unless you are a permit holder. There's an exception for permit holders under federal law, or unless the firearm is locked in the vehicle, which is not the requirement under 1313. So it is possible that an 18-year-old under this bill could transport and store a firearm in a locked, either locked in their trunk or in a locked box in their vehicle under this law and federal law.
Representative Stewart?
No, that answers the question. It just sounds like we're enabling pretty much every senior after Christmas to take a gun to campus. That'd be a concern of mine. I don't think we need more guns on school campuses.
Representative Smith, and then I'll turn it back over to Chairman Farmer.
Thanks, Vice Chairman. I wanted to direct this to legal. So is that citation of federal and state law predicated on the absence of a local or property owner's policy? If there was already a school policy that was posted at the perimeter of the property that firearms are prohibited, because that's the case in my school, in my district that I serve. If it was posted, if it was marked, if it was the policy of the institution or the property owner, would the federal law still negate that, or do property rights prevail? Thank you.
So 3917-1313, the state law, overrides any posting or by the private property owner or by the school. So 1313 says that a permit holder or a constitutional carrier, as long as they're transporting and storing in accordance with 1313, they can do it. Now, 1313 only applies if you are in compliance with the federal law, which means you need to either be a permit holder or have it unloaded and locked. But so right now, that's 21 or under 21 with military service, and under this bill, that would be to 18.
That take care of your questions. Members, we have 3 minutes, and then we're going to vacate the room. We got 3 minutes, so you recognize.
While we're out of session, I'm going to ask legal questions as well.
Hold on 1 second. Representative Stewart, do you have a question for legal?
Just to clarify, so it sounds like the point is, lock is not, doesn't really matter if you're a permit holder. The point is, permit holder is an exception under the federal statute, right? Okay, so the point is, if this law were to pass, then pretty much after Christmas, everybody in the school can bring a gun to school and leave it in their car. That's the way I'm reading this. Every senior.
This is Sonia.
If they're 18 and either a permit holder or the firearm is locked and unloaded, then yes.
Thank you.
Very good. All right, members, any more questions for legal? We're out of session. Oh, no. Okay, for legal. All right.
Thank you. Do you recall when this law was changed? Because I remember going to high school, we had pickup trucks and people had 22s and stuff sitting on the rack in the back of their truck. Do you know when that law was enacted and changed, just for curiosity?
Ms. Sonia, you know the answer to that question?
I don't have the answer for the federal law, but the state law was enacted in 2013. So before that, it was prohibited by state law.
Very good. All right, members, any objection about going back into session?
Just one quick question, if I could, for her.
Yeah, go ahead.
Long guns. Can 18-year-olds carry long guns on school property now?
The federal...
In their vehicle, locked in their vehicle.
I think right now the federal prohibition is for any firearm. So that's long gun or handgun.
Well, this shouldn't change that.
You're recognized, yeah. Does it, will it change that?
It won't change whether it's a long gun or a handgun. That distinction won't change, but it will change the permit age and so an 18-year-old who's a permit holder or or possesses unloaded and locked would be able to long gun or handgun in their car in the school parking lot.
Okay. All right, members, any objection from going back in session? Seeing none. All right, back in session. And what we're going to do, members, is we're going to, without objection, we're going to roll this for lack of time right now. It looks like there's quite a few questions. I think that maybe this may help Representative Todd between now and next week. But members, without objection, we're going to go ahead and roll this bill until next week due to time constraints. So with that said, do I have a motion to adjourn? Very good.
Sorry, Mayor.
Excuse me? So House Bill 1735 rolled 1 week. And we're adjourned. All right.